Welcome to Employment Law This Week. I'm George Whipple. Federal agencies are moving to ramp up enforcement while also working to advance the current administration's policy objectives. That approach is leading to real changes in how the nation's employment laws are enforced. Today, we review shifts at 3 major agencies. First up, the NLRB's General Counsel, Carey, issued a directive that instructs regional offices to prioritize timely resolution of current cases over new enforcement to reduce the agency's backlog of cases. She directs regions to approve informal board settlements and grant withdrawal requests based on non-board settlements where the parties agree and the parameters are lawful. Carey points particularly to cases where an employer's rule is alleged to be illegal, but there is no evidence of enforcement or actual harm to employees. She also discourages the use of enhanced remedies in settlements except for those violations that are egregious or recidivist. Meanwhile, the Department of Labor is instructing its lawyers to prioritize enforcement at non-union workplaces. Solicitor of Labor Jonathan Barry issued an internal memo asserting that unions are better positioned than the agency to address punitive harms to workers in unionized workforces. The memo reflects a shift in philosophy towards limiting federal involvement where other safeguards are present. Barry notes that the approach should be adopted flexibly, particularly in cases where the union or collective bargaining agreement is inadequate to protect workers. Finally this week, EEOC enforcement is back and laser-focused on DEI. Chair Andrea Lucas issued a warning directly to employers. Policies showing preference to any population for job-related decisions are unlawful under Title VII, whether the employer intends the policy to combat bias or perpetuate it. In a letter to Fortune 500 CEOs, GCs, and board chairs, Lucas states that systemic investigations, pattern or practice lawsuits, and large-scale federal litigation are all back on the table now that the agency has regained its quorum. The letter promises scrutiny that goes beyond mere labels like diversity and focuses on outcomes. The letter does not require employers to abandon diversity efforts, but companies should consider retaining counsel to conduct a DEI risk assessment. That's it for this week. Thank you very much for watching, and we'll see you next time.